Mr. McKinney, you're the one that brought this thing, so I usually leave it up to the state, but Mr. Brimhall may have a better handle on this one because with 3 lawyers involved, it's going to get complicated.
I don't mind reading it, and anyone can jump in and correct me or
All right, go right ahead then, Mr. Brimhall. So we'll go
right.
ahead and get this one done.
This hearing opens with ad litem appointments, temporary orders dating back to September 2025, and a motion to reconsider already on file. Translation: this case has history. Fees, indigency, and accountability are front and center. Stay with me. Subscribe for more dramatic courtroom breakdowns and real family court insight.
DFAM 352,719. This is in the interest of Flores minor children. Non-custodial party is Demetrius Flores. Custodial party is Courtney Johnson. And this matters before the court on a written petition seeking affecting parent-child relationship involving 2 children. The court will take judicial notice of the court file. Now, for the record, both parties have previously been noticed and served that we've been operating under at least 1 temporary order. Looks like since September of 2025, they make this second one here kind of thick. So anyway, there is a temporary order in effect in this matter. Court will note for the record Ms. Kuzak is present. She was appointed. Ms. Kuzak, were you appointed as guardian ad litem or attorney ad litem?
I think originally it was in the as guardian and attorney ad litem, and then that was part of the de novo process. And right. I think so, landed as attorney.
And the district judge changed it to guardian?
The judge did change it to guardian ad litem, and then at the last hearing, the motion was granted, and then I went to attorney ad litem, I believe.
Okay, thank you. All right, so you're still back to attorney ad litem at this point, and that was okay. That's what I was confirming. Anyway, the court will know for the record the state has filed. That's was it that quick? Okay, a motion to reconsider our reform judgment, and that was back on 10/31/25. Was that the motion to the district court, Mr. Welch, or something else?
That was for district court, Your Honor. The district court judge's initial ruling was that keep the appointment of Ms. Kuzak, but change it to guardian ad litem instead of guardian and attorney ad litem. And then we filed a motion to reconsider reform. And so Ms. Kuzak, agreed that she be named as just an attorney ad litem. The court took payment of fees under advisement and then ruled on that, stating that the case to be remanded to associate judge for findings and order outlined in Texas Family Code 107.023. And Your Honor, you made your rulings as to the merits, the most part of this case, in our last setting on February 12th. And so today, Your Honor, it's just about Ms. Kuzak's costs. So that's about it, Your Honor.
All right, you say the non-custodial party is not present today, is that correct?
Correct, Your Honor.
All right, then. So at this time, I'll go. This deal, Mr. Welch, I've checked with the district clerk's office, and any and all attorney fees, ad litem, guardian ad litem, they're billed by cost by the county and is listed as such. And obviously, the county can reimburse, do anything they wish to seek the refunds of those funds one way or the other, but the clerk lists them as costs that are owed to the county in one manner, way, shape, or form. And I'll probably clarify that to make it a little easier for them if they want to exactly put this against a single person for that reimbursement. But the district clerk's office has informed me that that's how they do it. Have you heard, Ms. Kuzak, you know anything differently than that?
No, Your Honor. I think what we're dealing with today are the issues of how I get paid, not
right.
Okay.
Right. And again, the state, I know the state wants me to go ahead and on circumstances, I can go ahead and order the parties to put money into the registry of the court. I can find that they're interested, and under certain Texas Supreme Court rulings, go ahead and order the county to pay that. But no matter what the circumstances are, the county can get their reimbursement from both parties jointly and separately if they wish to. So that's what I'm looking. That's my understanding.
And so at the last hearing, the non-custodial party was not there, but there is a criminal case pending and the court said that
Because he had
that you
court-appointed
were
counsel, yeah, but okay, this is that case.
right.
A couple of these cases floating around. So I found out that because he had court-appointed counsel, he's been found to be indigent, and that the county should pick up that cost and ask for reimbursement. And I'm probably going to look at making him 100% responsible for all that. Once the county seeks reimbursement on that aspect of it. But I'll get some testimony from mom to see what her expenses are and whether or not she's receiving any temporary support, that sort of thing. Because I got no data on that at this point.
And Judge, you took evidence on that on the 12th as well. And I have that as part of my notes from the ruling that you found that mother was also indigent. I don't know if Mr. Welch has those notes as well.
I got this one confused with another case where mom is, she's not affluent, but she's getting there. Okay, so and that is not this case. Okay, so.
Yeah, the court already took some evidence, as I remember. We went through some basic outline, some basic, income bills kind of situation.
Right,
and then you also asked if she was receiving child support, and she has not been receiving child support, I believe.
Right. So again, this is that case. Again, I'm sorry, my confusion. Again, I got another case just like this, but mom's a lot better off. The other day, the judge was looking at a new $700,000 house. Yeah, that's not.
That was not this one.
No, that's not this.
And mom's here. Mom's here as well. That's Courtney Johnson. She's here as well.
All right. So at this time, I'll go ahead and let both of y'all make opening statements. I've already made the finding as far as indigency, as far as the father's concerned. I'm going to go ahead and order that any and all costs. Right now, the county will reimburse any and all costs to the ad litem, and of course I'll make that the responsibility of the father since he's not paying child support. I'll let the district clerk office specifically have the right to go against him for the reimbursement of the ad litem fees. So, is there anything specifically that the state is requesting on this one, Mr. Welch?
Your Honor, so I'm completely fine with Mr. Flores being responsible for all of her, fees and costs. I would strongly prefer the county not to be involved because, Your Honor, it's the court cannot award, the county cannot pay for the cost because according to section 107.
I'm not gonna go into arguments on this one, sir. I've done what I've done. Okay, you can take me up on appeal if you wish to. Okay, well, I'm gonna find based on the indigency requirements of the and I don't have to. I'm not gonna go look up the full case on law on this again. But I'm finding that the parties are not are indigent and not cannot afford this, and I've appointed it based on that, and that's what I'm going with, sir. So have fun with it.
I understand, Your Honor. So just to make sure I understand your ruling correctly.
First off, I'm finding both parties are indigent. Okay, father's already been found to be eligible for court-appointed counsel. Mom is not receiving child support from dad and is 100% responsible for the care and needs of the children. And I'm finding that she is indigent. And based on that, and I'll look the case back up again. I hadn't looked at it in a few weeks now. But under a Supreme Court case in the state of Texas, if so found, then I can go ahead and order that the county take that under those circumstances, the county can reimburse the ad litem, and that's what I'm finding, sir.
All right, Your Honor. And how much that amount should be?
Right now, I'm going to. Right now, I know we already paid some. Right now, I'm going to set that amount. That Dad was actually out in the free world, I would tell him to put $1,000 in there. But for right now, Ms. Kuzak, right now it looks like I've already paid you $800, a few hundred and some change. You know what the final amount we're looking at, ma'am? And again, because the district judge did some of this too, I'm looking at having to reimburse you for that too. So have you got a final bill on this one yet, ma'am?
I can get you one in about 10 minutes.
Okay. I'll tell you what, Mr. Wells, let's go off the record and let it get a final bill, and I'll see how we're going to set this one up, okay? Thank you.
Yes, Your Honor.
All right.
All right, we'll get back on the record then. Thank you.
Thank you.
All right, we're now back on the record on Barrow County Calls number 25 DFAM 352719. So at this time, Ms. Kuzak, what's your final calculations, ma'am?
Up to this point and including final hearing or final order review, it would be an additional $382.50.
And the court was $382.50. I'm sorry, what was it again, please?
$382.50.
All right, so
You know,
the file,
and I've already been paid for other ones, but
okay,
from
I'm looking at it's in the court file, $323, so 382 on top of that.
And
I
I
think
can,
they're.
615. So
Do you want all three together, Judge?
yes.
Okay. The one is 323, and then the other one is 127.50,
Okay.
and then this one is 382.50.
All right. The final amount will be 800.
33.
I'm sorry,
I think
833.
it's 833 total.
Okay. And of course, my pen must have fallen in the trash again. I lose more pens that way. Oh no. Next to my coffee cup. Never mind.
Here's the financial hammer: $833 ordered into the registry within 30 days. The judge makes it crystal clear. The father is responsible, especially since child support hasn't been paid. This isn't symbolic, it's enforceable. When courts start setting payment deadlines, compliance suddenly becomes very serious.
All right, so I'll order that this father is responsible for depositing $833 into the registry of the court. I'll give him 30 days from today. So and there's no, we don't have a final order yet. So anything that needs to be done before a final order becomes final, that we can get it done if necessary. But this time, like I say, I'll order an adjustment of $833 be ordered against the father, and that amount be filed with the registry of the court on or before the 5 p.m. on the 26th day of March.
So, Judge, so to be clear, I have to wait for him to put that money
No,
in,
ma'am.
and then I've got.
No, ma'am. That's
Okay.
reimbursed the county. No, ma'am. You can go ahead and put
Okay,
the mail in.
Okay, great. So do I just do a fee voucher, typical one for the?
Yeah. That's good.
Okay,
Just
great.
put a little star asterisk on it. This is this one has a judgment for this. This is the one that actually has a judgment that the father is responsible for. Something like that.
I understand that now. Thank you,
that
Judge.
That way the clerk can see it and do what they need to do.
Okay, thank you, Judge.
All right. All right. Anything else, Mr. Welch?
I think that's it, Your Honor.
All right. Thank you all both very much. And Mr. Welch, everything else is finalized, correct, sir?
Yes, Your Honor. In fact, I've got a proposed order for all the merit stuff, and I'm hoping to have this fees and costs to get that done like in the next 5-10 minutes. And
I'll tell you what, save it to this Friday to send it in, and that way, in case somebody needs to do something before we remove before the 30 days is up. Well, okay, no, I'm sorry. You go ahead and send it in anytime. This is the month that doesn't have 30 days in it, so we'll have a couple of days push no matter what. So, yeah, I keep forgetting about good old February. I got paid. We get paid early. So. All right, thank y'all both very much, Mr. Welch, Ms. Kuzak, and I'll let y'all prepare that order, review it. Now I'll start. Ms. Johnson, do you have any questions, ma'am?
I don't believe so.
All right, thank you very much, Ms. Johnson. Thank you very much, Ms. Kuzak. Thank you very much, Mr. Welch. We're off the record. Thank you.
Thanks,
Your Honor.
Judge. All right, Ms. Kuzak, did she leave?
I thought she had one. She may have something at 1:30, so I'm not sure. But I heard the ding.
Yeah, she may have went to. Well, that's a 10:31. But well, in any case, Ms. Johnson, I'll move you to a room. We can look over this.
Okay.
All right, I'm moving you, ma'am, to room 11.
Get this on the record. I'll hear what the agreement is, and go ahead and get started. At this time, court's on the record, and this is Bell County Cause number 24 DFAM 347583. This is the interest of Johnson, minor child. Non-custodial party is Mr. Nicholas Mr. Nicholas J. Carter Maddox. Custodial party is Patricia Renee Johnson, and this matter before the court on a petition to establish parent-child relationship. course, taking judicial notice of the court file, note for the record that both parties have previously been noticed and served with citation. The court did order DNA paternity analysis by court order back on the 31st day of, wow, this has been a while ago, of January of last year. Anyway, the court will note for the record, my understanding that both parties are present, counsel are present, and I'll need for everybody to identify. Let me get the last reset order in this matter. Yeah.
Is Mr. Bowden, are you there, Mr. Bowden, your client?
We're here.
Okay. All right. There you are. Okay.
All right. Mr. Bowden's present with his client, and Mr. Maddox is present pro se. Is that correct?
No, I represent him, Your Honor.
Okay. You're not the ad litem. You're the, you're actually,
No,
you're
Mr.
I'm
Mr.
the
Bramhall is the ad litem.
I'm the ad litem. Yeah, this is a triple
okay.
attorney, quadruple attorney case, I guess.
Yeah, the rare among 4D cases. So anyway, both parties are represented by counsel. The state's been represented by Mr. McKinney. So at this time, I'll ask somebody to give me an opening statement to tell the court what you understand the order to be, whether or not it's going to be a final or attempt, and what the agreements and any contests are at this time. So, Mr. McKinney, you're the one that brought this thing, so I usually leave it up to the state, but Mr. Brimhall may have a better handle on this one, because with 3 lawyers involved, it's going to get complicated.
I don't mind reading it, and anyone can jump in and correct me or
All right, go right ahead then, Mr. Brimhall. So we'll go ahead and get this one done.
Okay, so my understanding is that the following, this is going to be a temporary order. We are requesting a final special setting for sometime in May on either a Friday or a Monday, preferably in the latter half of May. The parties will be named joint managing conservators, with the mother deciding the residence in either Bell or Coryell counties. The child support will be $431 a month, payable by Mr. Carter Maddox to Miss Johnson. Mr. Carter Maddox will also be ordered to carry the health insurance and dental insurance for the child, preferably through TRICARE as soon as possible. There's going to be an exchange of the child's copies of the vital records of the child so that he can add the child to TRICARE. And then there is going to be drug testing for both parties within 10 days of the court signing the temporary order. And that's going to be both a 10-panel hair follicle test and a UA. And both parties are going to be responsible for paying for that. I believe Miss Johnson is going to be using the any lab test in Harker Heights or Killeen or whichever one is there.
It's only Killeen now, sir. Yeah, Harker Heights take the shit down.
Okay, in Killeen. Mr. Maddox is going to have to find something close to Fort Polk, Louisiana, which is where he's at right now. And that, again, that's going to be within 10 days. The periods of possession are going to be as follows. It's going to be a 2-step thing, and then for step 1 is going to be 4 days in a row, actually starting tomorrow. On specific times. I believe it's, let me see, I have it written down here. It's 4 to 7 tomorrow, noon to 6 on Saturday, 4 to 6:30 on Sunday, and 3 to 7 on Monday. Again, it's the next 4 days after today, actually. The Friday, Saturday, and Sunday are going to be supervised. There's 4 different individuals that the parties have agreed on that will do some or all of the supervising. And then the visit on Monday will be unsupervised. And the exchanges will occur at either the child's school in Gatesville or the police department in Gatesville or the police department in Temple, based on who's picking up and where they're picking up from. Neither parent's going to remove the child from the current school, which is in Gatesville. And that's step 1. Step 2 is going to be from March 26th to the 29th. Or sorry, I guess it's the 28th. Yeah, it'll be the 29th, yeah. So 6 p.m. on the 26th to 2 p.m. on the 29th. Mr. Maddox is going to take the child to and from school on the 27th, which is a Friday. And none of these overnights, none of the periods are going to be supervised in the second step at all. The exchange provisions from the first step are going to continue. And then once we get through those first two steps, we have, I guess, a third step that will be the reoccurring ongoing step until a final order. And this step requires Mr. Maddox to designate 4 days within each month that he will have possession and access of the child. And he will communicate both the start and end days and times to Ms. Johnson at least 14 days prior to the beginning of that period. And to the extent possible, we'll try to designate days that don't interfere with school. And of course, this step will not be supervised either. And then
Now the focus shifts to possession, a structured step-up plan, supervised visits first, then unsupervised overnights, plus drug testing within 10 days. That's cautious but progressive. The court is balancing safety with parental rights. These temporary steps quietly shape credibility before the final hearing.
And so it'll just be 4 days a month, designated by him 2 weeks in advance every month going forward until a final order. And I think we can get through, for sure, all 3 steps before the next court date is the plan. And I think that covers everything. I'll let my esteemed colleagues correct me if I've misstated anything.
All right, well, we'll start with Ms. Gustafson and then go to Mr. Baldwin. Thank you.
I believe that covers the possession and access agreement, Your Honor, and the other provisions that we discussed to get us to a final hearing. There is a counter petition on file regarding conservatorship. So we do need probably at least 3 to 4 hours for a special setting.
All right, then, Mr. Baldwin.
I think the only thing I'd add to the recitation of the agreement is it's understood that when the overnights start in March, that Mr. Maddox is going to be with the child at his sister Nicole Weber's house. And I guess after the March visit, if that changes, he will let mom know, where he's going to exercise his 4-day period of possession, just so she knows where the child is, basically, because I think he's going to be exercising his periods of possession in Texas, at least until we get back to court. So that's all.
I'll let y'all iron that out if necessary. Folks, Judge is probably looking at taking time off and to get his, get that knee replacement thing going. So I'm probably looking at the first couple of weeks in June instead of the late May. Would that work with you guys? For y'all to come in?
Yeah, that'd be fine. I think that'd be fine.
In this case, probably based on this circumstance that's so negotiated, if I'm still not back, then Judge Law will probably take care of it also. But I'd like to keep it on mine. And right now, I know y'all saying I know Friday's supposed to be okay. I couldn't remember, was it Monday or Wednesday y'all were looking at?
Monday afternoon, or anytime on Friday seems to be the best for all the attorneys. So, and I don't, June is wide open for me. So any Monday or Friday in June works for me.
All right. The only Monday I don't have is the second Monday of the month for Comanche County. So I could do it. I could do it any Monday. And you say you want the afternoon and not the morning, correct?
I mean, I'm fine with the morning. I assumed there was. I assumed the court had,
okay, I got both slots available, 3-hour slots. I usually do 3 hours. I got the 9:30 slot available, and I got the 1:30 slot available on all Mondays and Fridays, except for the second Monday of the month when it's the Comanche docket.
Okay, yeah, I'm good with any Monday or Friday.
Any of those.
You have a preference?
Any of those is fine with me.
Okay, how about you, Mr. Bowden?
I'm sorry, we're talking about the first 2 weeks in June?
Any Monday in June except the second Monday, and any Friday in June except any Friday in June period is okay. So everybody else says any of those Mondays, the first one, the second one, the third, and the fourth one is fine. Any Friday is fine with them. The first one, the second, third, or fourth one. If you have a preference on any of those, sir, let me know.
Monday the 8th and Monday the 22nd would be my preference if we're picking.
22nd, well, Monday the 8th is my Comanche docket. So the
22nd, fine. So June
22nd works.
June 22nd at 9:30.
Works for me.
Okay.
All right, folks, I'm gonna go ahead and make the Zoom code, and I'll get that out to the state, and y'all have that new Zoom code in the next few minutes. I'll go ahead and obviously I'm gonna go ahead and let y'all confirm this information with your clients that they're in agreement with this under oath. So let me go ahead and get them under oath, and y'all confirm that this is what y'all gonna do going forward. So at this time, I'll ask both the parties to raise your right hands, please. Do both of you solemnly swear or affirm your testimony you're gonna give here today is the truth, the whole truth, and nothing but the truth, so help you?
Yes.
Yes.
All right, thank y'all both very much. I'm gonna let the Mr. Brimhall call y'all as witnesses, and then let y'all's own lawyers follow up. And again, y'all heard what the agreement is. It's a long one. Believe me, the judge just wrote down, agree to break-in visits. Okay. So, yeah.
Okay.
Otherwise, I'll still be writing. So the bottom line is, I'll let y'all confirm that this is okay with y'all, with both of you, and we'll get that order prepared, and I'll go ahead and start working on the Zoom code. Thank you.
Thank you, Judge. I'll call Miss Johnson first. Can you hear me okay?
Yes.
All right. Were you able to hear everything I announced at the beginning?
Yes, sir.
Is that what you agreed to?
Yes, it is.
Do you have any questions about that? Any of it?
No, sir.
Okay. Any part that's unclear?
No, it was very well spoken of.
Okay. All right. I'll pass.
I don't have any questions, Judge.
I don't have any questions.
Okay. I'll call Mr. Maddox. Mr. Maddox, can you hear me?
Yes, I can hear you.
Were you able to hear me read or announce the agreement that's proposed today?
Yes.
All right. Is everything that I announced, does it constitute your agreement as well?
Yes.
Okay. Do you have any questions about anything that I announced?
No, sir, I do not.
Is there anything that you are unclear about as it pertains to the proposed agreement?
No.
Okay, I'll pass.
I don't have any questions, Your Honor.
No questions.
All right, Mr. King. All right, folks. I'm going to go ahead and let your lawyers prepare that order, circulate it, review it, and sign off on it. I've almost finished doing the Zoom code, but I'll have that out in just a few minutes. Is there anything else at this time, Mr. Brimhall?
No, nothing further, Your Honor.
Ms. Gustafson? Anything else, ma'am?
I'm sorry. I don't believe so. It kind of broke up for me. I had an alarm go off to tell me to join your 1:30 docket, so I apologize.
Oh, well, I hope you're not late. Okay.
Yeah, I hope not.
All right, yeah. Mr. Baldwin, anything else, sir?
That's all for today, Judge. We already have a draft of the agreement and order circulating, so hopefully we can all get that signed today or tomorrow, and we'll be in good shape.
All right, Ms. McKinney, anything else, sir?
The only thing I could think of was we're going to reserve retro for the final two, but that's it.
All right. All right, I'll see. Hopefully I'm the guy doing this, and I won't be limping as bad when I see you guys next time. So anyway, I'll see. Anyway, thank y'all all very much, and we're off the record. Let me get back as soon as I'll go ahead and get this Zoom code out, and then we'll look at get ready to do the 1:30 docket. We're off the record.
Thank you,
Are
Judge.
we on
Thank you,
a
Your Honor.
different Zoom code for the 1:30 docket?
No, it's the same code. It's the same Zoom.
Okay, so I can just stay here and not be late.
Oh yeah.
Okay.
Unless you want to go drifting out into the internet ether, all right? Yeah.
Mr. McKinney,
Makes you happy, Ms. Gustafson. That's fine with me. Thank you.
Mr. McKinney, would you move all the attorneys back to the same breakout room? I don't know if we're in the same one or not, but
I got you. I'll move us.
Thanks. Appreciate it.
1 second. No problem.
By the end, both parents confirmed the agreement under oath, joint managing conservatorship, $431 monthly support, TRICARE coverage, drug testing, and a June 22nd final setting. Temporary orders today, long-term consequences tomorrow. Family court rewards consistency. Like, comment, and subscribe for more shocking courtroom stories.